All right, somebody said balance of the morning. Talking about a little bit about me, a little bit about how I met Eric, a little bit about the real origins of equity. Now we're going to really get into start talking about the meat of equity for the rest of the day pretty much. Let's turn to page 7, number 13. Before we read this one, I thought of something new. I've never done this before. I thought this would be a good thing to do it right now. Throughout the whole weekend, I'm going to start asking you to think in equitable terms forever. I'm going to teach you what that is. So every time you think about what is equitable, you've got to have a starting point. Can a legal fiction, i.e. Chase Bank, love you? Because love is equitable. Can Chase Bank trust you? Because trust is equitable. Can Chase Bank have faith? Because faith is only reserved for equitable. Who has equitable? Living men and living women. Flesh and blood. When you start thinking equitable, you'll exclude the legal fictions. You just think about trust law. It is my will and intent and my purpose. It's with intent and purpose. Can Chase Bank have purpose? Yes, they can. Can Chase Bank have intent? No. No intent. Only a living man or a living woman can have intent. So start making a list. Now you know why love is in the Bible. It's because legal fictions can't love. Can't have faith. Only men and women can have faith, love, trust in each other. And you'll start thinking of more. You should have a big list. Anybody? Anybody want to take a stab? Can Chase Bank see righteousness? Oh, are you behind the curtain?
Not the curtain.
Maybe I should draw it on that board for you.
Nope, I'm good now. I can see.
Righteousness. Tim, I know I'm going to give you a hint. There's a word that starts with a J.
Joy. Joy.
Joy. When you write a trust indenture, it's my intent and purpose that my children enjoy this property. Enjoy. Only living men and women can enjoy something. Justice is a good one, but the legal fictions will convince you that they also have justice. Joy. We'll think of more as the weekend goes on, but that'll be our running equitable list, and you'll be conscious of that.
Different terms in the Declaration of Independence. Pursuit of happiness.
There you go. Happiness. Big one.
That's a state of being for any.
Yeah. Happiness. Well, joy, happiness. And these are trust words because when it's your intent and purpose that you bequeath happiness and joy, use of property.
What about freedom?
Yeah. But I'm not going to stand up again. Because now this is not fun anymore. Mentally noted. Well, next time I get up, I'm multitask. Now you guys are too smart for this already. No, it's great. It's so true. So start thinking equitable. Go into Black's Law and you look up equitable asset. How could an asset be equitable? How can an asset be equitable?
Because it's living and breathing. It's got soul.
How can an asset be living and breathing? It's just one of the most amazing things that just went over my head for years. An asset is equitable because it's under the power of a man or a woman sitting in equity. Now the asset's equitable. When the man or woman goes outside, I'm going to say private citizen because that's the proper word, because nothing outside of private citizen in this country is relevant to what we're teaching. So it's always going to be proud American national citizen of the United States. It's just a foregone conclusion. If I don't say it, I meant to, but it's one of those presumptions for the whole weekend. Everything I'm talking about is for the proud American national citizen of the United States. Without exception. None of this stuff would work without that status. Fact is, when you do trusts, you list the intent, purpose of the trust. An equitable asset are those assets only cognizable in a court of equity. The same private citizen goes out of a court of equity with the same asset, and it is not equitable any longer. It's as if you were to take a pair of glasses and put them on, and now you see equity, and then when you leave equity, you take off those glasses, and now you don't. It is that real, whether or not those assets are equitable or legal. So if you look at blacks, I don't have it in here, or maybe I do. No, I don't. But you can look up equitable asset in blacks and entertain yourself with that definition. You might want to repeat it about 10 times. Really see what an equitable asset is. All right. My favorite case, I have probably, I don't know, 3,000 cases. You would think that, you're probably thinking, well, how many trust cases really are there? Tens of thousands. Probably can't count them. I just came across the ones that I thought were appropriate for the course, and I put them in here. So you're getting the best of the best. Save you some time. Number 13. We're going to start talking about maxims. Now, this particular maxim, there's 20 of them. Let's talk about maxims for just a second. We're going to get into maxims a little later. There's people that teach trust law outside this room, and I know who they are. And they actually think there's only 12 maxims. And they're teaching everybody there's 12 maxims. It's because Gibson said there's a table of 12 maxims. Unfortunately, and me and Eric are always talking about this, once in a while we come to the realization that even some of these equity practitioners did not see the Jesuits coming. They just didn't see them coming. They probably knew of them, but they didn't see 1933 coming. What do you think Gibson would have done if he saw it coming? Probably would have published some work. I think someone did publish a work. Didn't they say the destruction of our country, something to do with Jesuitism? I think so.
7 Wars.
Yeah.
Or conspiracy.
Yeah. There was people publishing, warning everybody.
There was people in the know.
Oh, yeah. Yeah. The point I'm making is that there's 20 maxims in equity. Okay? Outside of this room, even at Gibson, you say 12, a table of 12, maybe 13. Well, I found it interesting one day when I really wanted to get to the bottom line. I started doing some research just how many equity maxims there really are. You go on Wikipedia, there's 19. Oh, that's weird. How come there's only 19? And when I look at the list, I can see exactly which one is missing. Equity regards the beneficiary as a true owner. Why would they be missing that one? That's one of the primary maxims of equity. Equity regards the beneficiary as a true owner. So when it's all said and done, there's 20 of them. Now, I found out when I started research all 20 and started going real in depth. It's one thing I studied the first 12 for the first 3.5 years. All of a sudden it occurred to me, these other 8 maxims, it really hit me like a ton of bricks why they weren't in Gibson's book. And we believe, Eric and I believe, and we won't be able to ever satisfy our curiosity, I don't think, we believe the power of the editing room, which is Tennessee was being run by the Jesuits, they just flatly said, Mr. Gibson, your book's kind of long, I don't see any point, let's take these maxims out of there. Let's just take these out. Okay. Maybe. I'm only speculating. But, wouldn't you like to know, that all of commerce, all, A-L-L, without exception, are based on 2 maxims of equity? How would you like to know what those 2 maxims are? Outside of this room, nobody knows this, that all commerce is based on 2 equity maxims. If you comply with these 2 equity maxims, you and your mortgage, your debts, your children, everything you're doing day-to-day life will not be in commerce. And you will be Galinda in the bubble. But right now, what you're doing is you're the one, I don't say myself so much, but we created commerce by our waiver of these two maxims. We waive them. So, we're going to talk about maxims. But the two maxims I'm going to talk about, and about commerce, I'm going to get to in just a minute, but I'm going to read this other maxim. So you know what a maxim is? A maxim does not need to be proven. It's already proof itself. So if you cite a maxim, that is the proof. So you know, outside of this room, all these statutes and codes people, all these common law people, whatever these people are doing, what do they got to do? They cite cases, statutes, UCC, right? That's in support of their, whatever they're doing. You know what we do? 20 maxims. That's the proof. How do you like equity so far? Only 20 maxim, guys. There's not 21, there's not 19, there's 20. Well, let's read this one maxim. Equity follows the law. Kind of an innocent maxim. Doesn't seem like it has a lot of power. Just when you think it doesn't have power, it's the most powerful. It seems innocent. Equity follows the law. This is what Blackstone would have you believe. He spread his works throughout the colonies in the early days. It took 100 years for our law scholars to finally realize how wrong Blackstone was. And of all the scholarship I've seen in trust law, there's only one guy they go to great lengths and write books about Blackstone, how wrong he was about equity. So if you ever get tempted and want to go read Equity from Blackstone, I'm telling you right now, he was wrong. Here's what Blackstone said. Equity just supplies the law with its inadequacies. It's just wrong. Because equity has its own body of jurisprudence and it shines by its own light. It doesn't need the law. Blackstone would have you believe that there's only the at-law and that equity supplants its want of harshness. It's not true at all. That being said, this is a 1957 Supreme Court of Michigan. Hack versus Concrete Law. Maxim, equity follows the law. Unlike equity's remaining maxims, this maxim is limited in its application and operates within a very narrow limit. Remember that threading the eye of the needle? This is it. Very narrow limit. Averting the Pomeroy, 4th edition. The maxim is in truth operative only within a very narrow range. To raise it to the position of a general principle would be a palpable error. Throughout the great mass of its jurisprudence, equity, instead of following the law, either ignores or openly disregards and opposes the law. Did you run that stop sign? Yep. Well, then you're guilty. Yes, I am. Guilty of the facts, ran the stop sign. However, I'm not guilty of violating its intent, soul, and spirit. Excuse me? Nobody was hurt, no property was damaged. And when there's a conflict between the rules of equity and the rules of law, the rules of equity always prevail. Someone asked me about state court. What state are we talking? Wyoming? Utah?
Wyoming.
Wyoming? We'll get to that. All right, maximum truth. It's operating with a very narrow range. Okay, as was shown in that portion of the introductory chapter which deals with the nature of equity, one large division of equity jurisprudence that lies completely outside of the law. It is additional to the law, and while it leaves the law concerning the same subject matter in full force and efficacy, its doctrines and rules of equity now, equity doctrines and rules, are constructed without any reference to the doctrines of law, of statutory law. What are they telling you? The source and authority of the body of equity jurisprudence has no authority from statutes. It comes before statutes. The statutes are just like 1 Timothy 9. They're for the profane, not for the righteous. The righteous are supposed to plead maxims. Okay? But it gets better, you know? But wait, there's more. Right down the middle of the paragraph. Another division of equity, jurisprudence, is directly opposed to the law, which applies to the same subject matter. They're talking about exclusive equity here, so you might as well note that. This is where exclusive equity pops up. Its doctrines and rules are so contrary to the rules of the law that when they're put in the operation, the analogous legal doctrines and the rules are displaced and nullified. How would you like to be under Maxim and find out that your law just nullified the at law? What if you had a judgment against you at law and you go into equity? They would nullify that case, extinguish it.
Or when he uses the term law, he's meaning at law.
That's right.
Okay.
It says the word law, he's talking about, and this is 1957, so this is after 33. Okay? We're going to have a few cases in here after 33 where the courts are flatly noticing the public. There's an entirely different set of rules back here in the court you guys aren't using. Hello, just let you know. There's an entirely different set of rules back here you guys are totally ignoring. Okay, if you want to come in the outlaw side and get your butt handed to you, it's not our problem. We told you so. Just doing our job. It's back here. Wink, wink. So let's talk about the evolution of equity. When it first started, the king turned to his right-hand man and gave him the keys to the kingdom and said, I want you to use good conscience and good reason. And I want you to go out and find the truth of who owns what lands and owes what rents to who, and just figure it out. Who's inherited, who's the beneficiary. We just got to find out the truth. Because I was off the war a long time, and now we got to figure out who owns what. We call it chancellor. It's still in England to this day. It's called the chancellor. And the chancellor was an immediate hit, just like Gibson tells you. 50 years into it, it was here to stay. People loved it. Finally, they didn't have to go by statutes and codes. They could get a guy running the court who would just use good reason and good conscience. Those are steep words. If you've ever been in a court case, don't you wish you could just say, hey, excuse me, this is really absurd. None of these people have no connection. Never met any of these people. And they're here taking my family, dispossessing them, desizing them of property, and they have no connection to this matter at all. What say you, court? Oh, overruled. So the rules of law. But so you had the common law. Well, you guys did such a good job cleaning this board, I'm going to mess it up again. So you have the law, I just call it law. It's a general word, but that's what it is. Statutes and codes, Pharisees, canon law. Please, it's common law. It's harsh. Now, the law loved what equity was doing. For hundreds of years, they wished they could be equity. You even see it in these books. They actually use the word love. The law fell in love with equity. So they wanted to borrow from equity. Because here's how it used to work. If you got a judgment at law, you'd have to go over to equity to get an attachment. Attachment is equity. If you got a judgment at law and you wanted to liquidate, you couldn't liquidate at law. You have to go into equity to liquidate. If you were at law and got a judgment and you needed discovery, you couldn't get discovery at law. No such thing. You had to go into equity to get discovery. So it was kind of a system that really, what it does, in my humble opinion, it exposed the limitations, the strict limitations of law. And the law knew this. So they started to expand. Kind of like McDonald's. They added more stuff to their menu. Okay? So they added this little piece. It's called auxiliary. Things like discovery. Now, if you're in a case at law, you could get discovery at law. It would just copy what equity would do. And you know, they did other things. They did attachment. They did replevins. They did writ of possessions. Oh, the big one is they did writs. They copied equity. All writs came out of equity. They would copy it. then that wasn't enough. They wanted more. So a couple hundred years goes by, and they create this whole other jurisdiction called concurrent. And this is where, for lack of a better description, this is where they're really selling you big time. Come on in. We have equity and that law in the same proceeding. Come on in. Absolutely. We'll give you full relief, just like equity does. Come into our concurrent. We merged them together. And even Gibson, Pomeroy, all the greats, the people who know equity, I'll spare you, you can read this at your own leisure, but you can go into 6, 7, 8 different sections of Pomeroy where he goes into great detail warning you that is not equity. It's a look-alike. They're trying to look just like it. But, and this is the piece that you'll struggle with. Maybe you won't, but you might. It's hard to understand why this jurisdiction and that jurisdiction will never, ever commingle. It would be the same as if you could be a married bachelor or a almost pregnant woman. Wet and dry at the same time.
They're trying to apply equity to artificial.
They're going to use equity in their decision making, but they're never going to issue a private decree over here. A private decree is never going to issue out of this at-law side. Nor its auxiliary, nor its concurrent. But they're going to act like it is equity. And this is going on for hundreds of years, right up to 1875. Judic Act in England. And I don't know, this is not a mythical story. I've read the story and it's just, I don't know, by God's good graces, somebody was paying attention. Over in England, they were going to pass a law that merges law and equity together. And somebody wrote a big article in the newspaper saying that it would be devastating to the body of jurisprudence that those two jurisdictions merged. And that's impossible. There has to be a conflict. There's going to be a conflict. See, isn't it obvious? I'm going to teach you that it's obvious. You can't answer this question yet. Hopefully tomorrow you can. In a court of equity, a man and a woman have all the rights. And a legal fiction is ignored. But then at law, legal fictions walk in there all day long, and do they have all the rights? Well, legal fictions go in that law all day long and have the rights. Who's ever been foreclosed on? Do you ever feel like you were never heard? Of course they do. So how can you have both equity, where a man or a woman has all the rights, and you can have at law in the same proceeding where they both have all the rights? Do you see how it doesn't mix? It's impossible. It's like being almost married. It's impossible. You either are or you aren't. You either in equity or you're at law. But Pomeroy and these guys tell you for 50 years, 60 years. Somebody wrote a letter in England and said that when there's a conflict between the rules of law and equity or the same subject matter, then the rules of equity must prevail. And they put that in the act at the last minute. And it passed. And our Judiciary Act, 1789, they amended it and put it right in our Supreme Court Judiciary Act. So we have it. Boom. When there's a conflict. You can write that. I've got it in there probably 4 times. When there's a conflict. You can say this in open court. When there's a conflict between the rules of law and the rules of equity over the same subject matter, the rules of equity shall prevail. It's just one of those things. You just got to learn to say it, plead it. And it's funny, people walk out of here, and I don't think they understand the teeth this has. This is teeth. We don't do statutes and codes. You want to give them teeth? Give them the conflict. And there's still someone who always walks up to me and says, well, what would I do in this traffic case? You know what my answer is? Plead the conflict. Well, I have this, divorce case going on. What should I do? I'm not your lawyer, but if it were me, plead the conflict. Because under the rules of statutes and codes, there's certain rights, and under the rules of equity, there's other rights. And when there's a conflict over the same subject matter, the rules of equity shall prevail. I worked with a guy in his divorce case. His ex-wife brought an attorney. He was a captain in the Air Force. So he's not, a law guy by any stretch. pretty simple guy. He wrote up a notice of conflict and variance of law. Notice of conflict or variance of laws. Whoops. Woo. And pleaded what the rules of law afford her and what the rules of equity would afford him. Because under the rules of equity, under good conscience and good reason, what is fair, just, and right was these sets of facts, but under statute, the ex-wife was entitled to those set of facts. We're not even talking a legal argument here. We're just talking about a conflict. He put that notice in the court. He showed up to the hearing. The judge asked him one test question, something like, can you give me a little background on equity in this country? Which he nailed. The judge turns to the attorney for the ex-wife, says, you're going to write up the order. He gets everything he asked for. The non-statutory pleading is higher. We worked on a tax case briefly. The same outcome. In fact, what was funny about this is the IRS was suing this guy, and he pleaded the conflict with rules of equity law, and he formed a trust, which I'm going to show you how to do, over the same subject matter. He put the documents in the chambers, and the judge, not really knowing how to decide the matter, he wrote kind of one of those judgments where nobody really won and nobody really lost, and it really ticked off the IRS. So the IRS came back and said, no, Judge, that's a horrible order. We want to know who won. You stated for the record who won and who lost. So the judge says, okay, you have to withdraw your claim because the non-statutory claim is higher. And they were stunned. The non-statutory claim is higher. Everyone outside these doors are chasing statutes and codes. Think that's by accident? Or you think they just got us all trained? Good kids. Stand in line. Don't ask questions. Raise your hand. Don't talk. Don't you like that? Don't talk unless you're spoken to. Answer me! Right? So the Judicature Act of 1875, we're on page 7, number 14. Judicature Act, generally in all matters, when there's a conflict or variance between the rules of equity and the rules of common law, or just say law, with reference to the same matter, the rules of equity shall prevail. So plead the conflict or variance of law versus equity. Okay? Now, for the next page or two, I took the liberty of putting as many states that I could find in short order of that same exact thing that's in all the states. And I found quite a bit. I didn't get all of them. I was surprised I even found Minnesota. There it is, 1910. Supreme Court of Minnesota, Section 3140. When there's a conflict and variance, and this state also adopts the same principle. You know, there it is. In your jurisprudence of the state, so it's in all these states. So, let's look at them. We got what? North Carolina, then we have Mississippi, Supreme Court. The next page we have New Mexico, then we have Michigan, then we have South Carolina, Supreme Court of Michigan. Then we have Idaho, then Utah. Okay? And there's a whole lot more. I mean, I didn't want to make this book huge, so I was cutting corners. But every state in the Union follows that same principle. When there's a conflict between the rules of law and equity, the rules of equity always prevail. So now you found out you never knew what the rules of equity are. So we'll start learning the rules of equity. So now we're on page 9. There. Joseph's story. Equity is the fountain of justice. Limitless. Grace. When you get Gibson's book, do a search for the word grace. Now I'm not talking about the judge's grace. The judge will never be so preposterous. He's brokering grace from God that was intended for you. Your debts are supposed to be extinguished. That's why he sent his only son to make that payment. And now we have legal standing before the Father. With legal standing before the Father as grantees of dominion. 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 We were granted dominion. Grace is the source of all law. when the chancellor writes a decree in equity, it's by grace and good conscience and good reason. We're going to see a case I'm going to go through. That's exactly what the words the judge uses, chancellor uses, by good reason and good conscience. All right. Now, here's the biggest thing you need to understand for now and ever. This is where I got with Eric. And once I showed him this is why I'm here. This piece I'm going to show you right here. Otherwise, it doesn't work for anyone outside this room. This is the exclusive. It is untouched. Because, and believe me, if they could touch it, they would. They can't touch it. Because all of these people, Jesuits, whoever they are, law practitioners, they're all defined by statute. And statute cannot go into that domain. Because why? It's non-statutory. You with me? Can't be almost married, almost pregnant. You can't be wet or dry. You're non-statutory in your maxims, or you're statutory. So here's what they did. This is just all public. That's all it is. And this, it's all private. And there's this curtain that's between them, between which there is no connection. It's by Dorothy. If she called the castle and asked for the man behind the curtain, it's not a coincidence that they use a curtain. Because in equity jurisprudence, when you get in deep level litigating equity, you guys hopefully never get that deep level, never need to, probably won't need to. But they actually use the words that the judge over here has to pass a document over the curtain to the chancellor in equity. They actually use that expression, over the curtain, and there's a chancellor behind the curtain. Okay, now, March 9, 1933. March 5th, we have concurrent, auxiliary, and law. Statutes and codes. Okay? March 10th. People wake up on March 10th. Everything looks the same, right? Sun still comes up. People are milking cows. Things are still horrible. People are still sending in soup lines. And FDR says, well, this is a day of consecration, right? Overnight, all of this got ousted. I told a friend of mine after I took Eric's course, called him up. I go, dude, there is no such thing as public. It's gone. Public was a word predicated on the word republic. A republic is predicated on a word of a group of sovereign men and women that get together as a group. That's a republic. Public is gone. It's extinguished. He goes, well, how can it be extinguished? What's there? I go, it's worse than public. And he had to think about it for a minute. He's like, well, what could be worse than public? Martial. And he goes, yeah, it's definitely worse than public. And all of this became martial. And what that means is that what the commander-in-chief military leader says goes. It's not based on sound principles. You could kick their butt on paper in court all day long. If they don't like you, you lose. I mean, it's not a coincidence you feel like they're not listening. They're not listening. They don't have to. It's called public policy.
Diesel therapy.
So in between Abraham Lincoln and FDR, there was only, I'm going to, correct me if I'm wrong, there's 4 executive orders? 8? It was a handful. Between Lincoln and FDR, there was a handful of executive orders ever filed with the Congress, to which they have to follow and abide. After FDR, between FDR and now, take a wild guess how many executive orders they've issued out of that military leader commander-in-chief's office. Tens of thousands.
Now, would those executive orders came during a time of war, like civil wars?
We are at a time of war. That's why they
Well, I
keep
know
issuing them.
that would have been the justification the first time. That small
Correct.
handful.
It was a de jure decision from a de jure president
That's important to know.
of an organic de jure Congress issuing valid de jure executive orders. After FDR, all law comes out of that one office. So, here's me. I go through the airports. You go through and see the TVs are on. They're all watching CNN. And Obama has threatened if Congress doesn't get together on immigration policy, he'll just pass that executive order all himself. I start chuckling. And everyone's, all up in, oh, you can't do that. Oh, Congress will be all mad at the president if he goes on without them. Nah, nah, nah. And me and Eric, we just kind of chuckle. There's no fraud here. It is totally legal. The Jesuits won that battle. War's not over. But that battle they won. Overnight, everything became martial. So you're not getting true principles of law anymore. So now you're walking into court, and it's just based on whatever they want to do. I'm not even sure how they decide half these cases. I got to be honest, these same judges in Applet, when they look at mortgages and foreclosure, they must bite their tongue. These law practitioners, and they know what's going on. They've got to follow public policy. If you ever heard like a jury, when a judge turns to the jury, will you administer the law as I give it? And it wouldn't be different if he said, will you administer the law as God gave it to us? That'd be a little bit different order in court there, don't you think? Yeah, that's not the way they do it. Will you administer the law as I give it? That being said, all you got to remember is that on that fateful day, there is only 2 jurisdictions running in this country. That is it. And outside this room, you're going to have people argue to death. There's admiralty. No, there's not. Well, there's tax court. Wrong. Well, there's bankruptcy. No. It's all martial. Statutes and codes administrated by public policy. If you ever go to D.C., I got to go there not too long ago. Stood in front of the White House, got some pictures. It's kind of cool. First time ever there, Running around in a rented car. And there it is, the University of Public Policy. I was laughing. There it is. That's exactly what it's called.
University of Public.
Or College of Public Policy. Right there, not even a half mile from the White House. So I was going to throw a rave party there one night. So there's only 2 jurisdictions. This is hard to swallow. This is why I kind of go slow. This is stuff that's paradigmatic, meaning your whole paradigm. If 2 days of Eric isn't enough, now you get me. We're going so far down the rabbit hole right now. There's only 2 jurisdictions out there. Martial and what Marshall can't touch, which is called exclusive equity. All right. And I mentioned here in page 9, 16, pre-33, post-33, the 3 heads of equity, auxiliary, concurrent, exclusive. And what you have here is Gibson in section 21. He kind of have it in a weird order, but I'm going to read B first. And I tell you, this is me talking, do not call the courts looking for a court of equity. It's not a court, it's on your paperwork. Okay? It's not cognizable in public. Like, you can't go into the public and say, hey, I'm the beneficiary of a private trust. And they're going to go, whoa, call the press. Excuse me. Come on. They're not going to acknowledge any authority. Think about it. If they acknowledge you have any authority whatsoever under rights of trust law, and they acknowledge it in the public, what are they doing? What are you doing? You're commingling. See? So now you got to learn how to not commingle and keep your right. So you get the highest right in the land. But then you go in without the bubble. You go into court, out of court, into chambers, out of chambers, and you just learn which side of the ledger you're on. See? But the beautiful thing is, through trial and error, I think I figured out how to get every one of you into equity for just trying. And I couldn't say this a year ago. I'm going to go out on a limb and say that. For just trying, you might have the worst bill in the world. You might even have a bill that's going to get kicked out because you don't know what you're doing. Like, things like, you do a bill and you bring all these legal arguments in your bill. Like I saw someone wrote, well, they open up my envelope and then put it back in, and that's fraud. That's a legal claim. There's no equity in that pleading, you know. Or fraud. That's a legal claim. The beautiful thing about equity, you don't even have to plead fraud. In equity, fraud is presumed without you even having to plead it. That's kind of nice.
Yeah, because you're there for damages.
Damages is a legal claim. Now, destruction of rights, that's equity. Violation of rights, that's legal. Damages, legal. We had a guy, well, SWAT came in and they damaged me and my family and knocked down our door and it went on and on and on. And I'm like, that's a legal claim. They're probably going to kick you out. And what did they do? And he was sealed. He was doing good. I can get you in, but you got to do this on your own. You can't litigate everybody's stuff. You know, I have a day life, you know. But I think I'm going to do my part here. I think you're going to see that tomorrow when we talk about how to do this and the paperwork, and my private paperwork I could bestow and that you can understand. You can change, modify all the stuff you want. This is literally stuff that when we get into it, you're going to see the value that it has. Okay, so don't call the courts. Exclusive is untouched. So let's talk about that. Let's talk about drinking some water from a pretty bottle. Pomeroy, section 354. Somebody not too long ago, they came out of my our 4-day course, my 2-day portion of it, and said to me, I don't know, I'm still pretty skeptical that exclusive really exists. And I'm kind of looking at them going, So Pomeroy means nothing to you? Really? Because every judge in America, even on the Marshall side, will listen to Pomeroy. You may not win if you're on the Marshall side, but you can put it in there and they know what you're talking about. Pomeroy 354, you can put this in your pleading. These are put here for a reason. You don't have to go looking for them. To sum up this result in one brief statement, all equitable estates, interests, primary rights, and all the principles, doctrines, and rules of equity jurisprudence by which they are defined, determined, and regulated remain absolutely untouched in their full force and extent as much as though a separate court of chancery were still preserved. You could be in a state where they've never had a court of equity in their history, and there's still a court of equity sitting there on paper. But you're never going to call the court and find it. It's never going to happen. It is the oddest thing about this law system. Hey, the Trading with the Enemy Act, Mercy Bank Relief Act, have you noticed it's only on paper? I mean, did any of us move into enemy territory? Did you move? I didn't move. We all stayed in the same place. What changed? The definitions on paper. They changed the definitions on paper, and they can treat you like an enemy. We didn't move into an enemy territory. They created one, so we already existed in one. What they do is they look at 350 million people or any population, and they already know that by default, everyone's lazy. Nobody reads, nobody understands law. So they know they can just pass these silly little changes, and everybody falls right into it. They love it. It's only on paper. I mean, think about how ridiculous. I mean, on the one side, it's ridiculous, but then on the other side, it makes total sense. God didn't want to commingle either. Even Jesus told the Pharisees, I'm the authority. You will see me sitting at the right hand of the Father. You're not the true authority. I bet that really kind of fried him. What are you talking about? So, look at B. This is 355, Pomeroy 1905. It is easy to say that the distinctive modes of equity procedures are alone abrogated by the legislature, while the principles, doctrines, and rules of equity jurisprudence and jurisdiction are wholly unaffected. Why are they wholly unaffected? Because they can't affect them. You cannot affect what you have no jurisdiction to affect. We're on 10, C. While the external distinctions of form between suits of equity and actions of law have been abrogated, The essential distinctions, which I believe that's supposed to say add here. It's a typo. When you copy paste from these old books, you don't get a clear paste. The essential distinctions which adhere in the very nature of equitable and legal primary or remedial rights still exist is clearly defined as before the system was adopted. The system he's talking about is the merger of the concurrent. This concurrent, the merger of law and equity. This is that warning he's telling you. They still exist clearly defined as before the system was adopted and must continue to exist until the peculiar features of the common law are destroyed. Well, that's a premonition. And the entire municipal jurisdiction of the state is transformed into equity. See, the commander-in-chief loves equity. He loves it. He loves it.
It's Roman.
Roman. Thank you, Eric. Almost forgot to mention that piece. Let's not go any further. This, Marshall, is Roman equity. And it's not fake Roman equity. It's real Roman equity. And that, I'm telling you, that what they did here, they brought the laws of ancient Rome into our country with that one act. Roman equity. And there is no resemblance between Roman equity and American English equity. And American English equity stands on its own and has no resemblance to Roman equity. I didn't invent it that way. That's the way the world's spinning. You know, there's always two types of people. Let's find out the world isn't the way it should be. The world just isn't the way it should be. And the world changed and the change, the world isn't the way it should be. There's that type of person. There's the other type of person that says, you know what? I don't know how the world really is, but let's go find out. And let's find out how the world's really operating and adapt to it. So we make heads or tails out of it and benefit from it.
Do they have similar maxims then?
No relation. There are no maxims in Roman equity. They're legal maxims. Latin, French, Greek, thousands of them. Legal maxims, but not equity maxims.
In my first volume, I have a chapter with Sir Henry Maine, with legal fiction, equity, and legislation. And there's about 4 or 5 pages in there that contrast English equity with Roman equity.
So, when you are out there in this country and you get the feeling that you don't have any primary rights like you were told you had, it's because you've got Roman equity. Roman equity is based on privilege. You ever notice when you stop paying your license, what do? They revoke your driving privileges. Okay? These are just privileges. You got to get a gun permit for the privilege of owning a gun. Privileges. That's Roman equity. All under the commander-in-chief, public policy, run by one office. Not even Congress can stop it. And it's totally legal. There's no fraud here. On the other hand, American English equity is only available to those who are protected by the very instrument that protects it. And that instrument is the Constitution for the United States of America. Because English American equity jurisprudence is absolutely protected under that Article 3, Section 2, Subdivision 1. The one thing you've got to be double sure is that you're party to that instrument. And you'll get people out on the internet, you can see it all day long. Well, you're not party, you didn't sign that document. You're under the rules of contract, and blah, 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 blah. I just laugh, shake my head, and walk the other way. Nothing could be further from the truth. Because under trust law, you're party to an instrument if you were intended to be covered by it. That is trust law. Trust law covers you because they intended it to cover you. That's all they have to say. And what do they tell you in that preamble? For the posterity. It's the way they wrote a trust indenture back then. They intended it to cover their descendants. People came here, born here, not born here, immigrated here. Everyone was intended to be covered. Even this erroneous thinking out there that Section 1 of the 14th is some kind of corporate, de facto, status change. No, it's not. It's just a broadened definition of the same thing. It's still a de jure government passing Section 114. It's not de facto. It's de jure. You must be covered in that instrument. So what happens when you show the proof that you're a private American national citizen of the United States on paper? Now you're showing them that you're entitled to American English equity. And oh, by the way, there's no more common law. I'll show you why. There's no common law here. It's gone. Common law was over there. And it's gone. In other words, there's not a separate legal system running. I said I was early on when I met you, hey, well, if we peel away the Roman, what's left? Is there another legal system standing behind the curtain? I had to think about this for a long time. I had to make sense of it to the best of my ability in law, in doctrine. And I'm thinking, well, that only tells me that there's only two jurisdictions then. There's only trust law, and there's only martial. Because if you peel away the martial, there's not another common law legal system waiting for you. So it's still futile to think you have some harsh fundamental rights and privileges, which, by the way, is equity, not common law. All your fundamental inherent rights, like the right to marry who you want, the right to oxygen, the right to clean water, the right to do, the liberties, this is all protected in that instrument. I'm going to get to Section 25 of Gibson. I'm going to tell you about how... wait, we're already there. I already guessed my own next step. Let's finish D on page 10. This is Pomeroy. Wait, that's a repeat. No, it's not. It's a footnote. Okay, well, we don't need to read it because it would be repeating. Well, let's just move on then. 18. This is the next illustration, and then I'm pretty sure I'm done with illustrations that you need to know. It's just like going to the Super Bowl. You have a game plan, you have your playbook. I'm giving you the two biggest playbooks. One, you better be a private American national, party to that instrument. Two, there's only two jurisdictions. There's only martial and there's only exclusive. And when I show you how to plead exclusive, then you'll get the idea. We've had some, I'm going to call it moderate success. We've got a few active cases going right now for the short time we've been teaching. A lot of people have got their cases sealed. Tomorrow we're going to talk about how to do it. And everybody's jumping on me with questions. Well, how do I do this? We're going to get to all the hows tomorrow. But I need to teach the whys. So somehow in your mind you're going to remember these two realms. They can't be commingled. It's not your fault, not my fault. It's just the way it is. Let's talk about Gibson section 23 to 25. This took me 2 years, and I had an epiphany one night. I just sat around thinking about this, going, what in the world? And I'm going to tell you why. I'm going to draw it on this board over here. Okay? Now let's read this very carefully. He's telling you, it's called the equitable versus statutory. He's already telling you there's two domains. There's the equitable and there's the statutory. He's not telling you there's the equitable, the statutory, and then there's family court. He's not saying there's the equitable, the statutory, and then there's admiralty. He's already telling you in 1907 there's only two jurisdictions, the statutory and the equitable. Okay? But let's look at the equitable. Here's the equitable. The equitable, or also known as the inherent, to include all those matters, whether purely equitable in their nature, so purely equitable by nature. Or having characteristics, both legal and equitable. So we're going to call this legal by characteristic. I can't spell. I went to Oxford and I'm ashamed. Okay? That's incredible hieroglyphs. You guys probably thought I was writing in English. I was Egyptian, hieroglyph here. So. Characteristic. Sorry. All right. Equitable by characteristic. Now, I want you to notice these words. Because we don't mince words. I don't mince my words. And he's not mincing his words. You got to ask yourself, okay, characteristic. You ever been to Disneyland and there's Mickey Mouse, he's walking around, you get pictures with him? Is that the real Mickey Mouse? The kids care? No, we all stand around and know that's the fake Mickey Mouse. He's the Mickey Mouse by characteristic. Fake Mickey Mouse. Equitable by characteristic? Now, look at the last sentence, how it says, jurisdiction over which is derived exclusively from their inherent powers as courts of equity. Equity has inherent powers. Inherent means no Pharaoh, no Pharisee, no Caesar ever granted the authority of a court of equity. A court of equity had its inherent authority from God. Okay? Let's look at the statutory realm. The statutory realm include all those matters, whether equitable in their characteristic or purely legal in their nature. Jurisdiction over which is derived exclusively or chiefly from where? Statutes. So on the one hand, we have inherent authority, and on the other, we have legal nature and equitable characteristic. Now, it took me 2 years till it finally hit me how crucial this was to understanding our current system right now. Authority derived from statutes. And who creates statutes?
Man.
That's a fair answer. Would you say that man still creates statutes today?
Yes.
Legal fiction.
Legal fictions create statutes. Would you say that, we don't know the answer to this, we can only guess, speculate. Would you say that the vast majority of people sitting in Congress passing statutes right now are private American national citizens?
No.
Well, they can't be there in that capacity. They could be when they go home, because remember Bouvier? 2 persons. When they go home to their families, we have Eric Holder just resigned, right there in his press release. Eric Holder is going to go home as a private citizen to restore trust in his community. I just fell over backwards when I saw that in his press release. Private citizen to restore trust. Can you imagine how many of our private American national statuses that guy's received in the last 6 months? Quite a bit. And nobody's getting any angry letters.
Roark, would you say that equitable characteristic is a Roman equitable characteristic? Would you say that?
Oh, clearly. Oh, yeah. So here's where the Jesuits are so brilliant. You got to respect them.
Can you repeat what he said?
Okay. He's trying to define what equitable characteristic is. That Roman equity? I said absolutely. Because you can't commingle American equity with Roman equity. That's like oil and water. They don't mix. They have nothing in common. What he asked was, and I'm going to get to this, let's talk about what that statutory realm is. Legal nature is pure statutes and codes. I mean, I'm talking about like a military style court-martial. You violated section 1.825 of a code. Code. Right? That's legal nature. Pure codes. what's equitable characteristic? Well, you can't commingle American equity, so the Jesuits took our own American equity and they codified it. And they pretend as though the equity you're getting, well, that's equity, and it's all codified. I mean, that's why they have the Trust Act. They're codifying trust law. The UCC is all trust law codified. Excuse me, I didn't mean to say trust law. Trust law is all throughout the UCC. But what the UCC really is, they looked at 600 years of English-American jurisprudence, and they plucked out all the principles, and they codified it in what's called the UCC. So, if you use their code, what jurisdiction are you telling them you're in? But it's equity, because it came from there, but we own it, so use our title. That's what it is, it's a title. I mean, like a car title. They created a car title, and you're driving their car. So who owns the car? You? They do. You've never owned a thing in your life under Roman equity. You've never owned anything. It's impossible to own any property under Roman equity. It's all privilege. Because guess who owns it all? Under Roman equity. Guess who owns everything under Roman equity? Caesar.
Caesar.
Do you think Caesar is going to change? I mean, all you have to do is look what the Jesuits do to these countries over the last 600 years. Go into Mexico. Is that a place worthy of our admiration? There's super rich and there's dirt poor. It's not a place I think God had in mind, you know. But the Jesuits run everybody into the ground. They're trying to do it here. That's why there's this wealth concentration with the Jesuits and their agents.
So was this almost immediately after the Constitution was ratified that they started this?
Great question. The moment the Founding Fathers put into motion the Declaration of Independence and 13 years later put in the Constitution of the United States, these people were hunted down and killed like dogs because the Jesuits knew what they had done.
In 1808, the Jesuits determined that America was a missionary country. In 1901, under Theodore Roosevelt, they withdrew that tag. So they were conspiring against it the whole 19th century. Pretty much, they set in motion and placed their empire by 1901 with Theodore Rex Roosevelt. But then when they imposed their de facto military government in 1903, then they took everything.
That's a great question because the Jesuits knew what they had done. They had formed a trust and protected us. And that trust law was going to give us the right to actually own property.
They drew the curtain right away and got people thinking statutes, and that's why it's so hard to see the
Eric?
equitable side of it.
Eric shows you in his course that they spent a minimum of 50 years plotting a path to overthrow our de jure government. Because if Roman equity is going to persevere and Caesar owns everything, they've got to be very careful that they do it, and none of this stuff's built on fraud. None of it. They just knew how to take our American English jurisprudence and work it against us. And I'm going to get to those two maxims. Those two maxims that operate against you every day. We'll get to that. I'm not withholding it. Just got to get through this one last piece.
I've been waiting.
Keep waiting. Don't go anywhere. Now, we've coupled the statutory, the legal nature, pure statutes and codes, equitable characteristic is fake equity. The UCC, that's equitable characteristic. It's still statutes and codes, just fake Roman equity. Now, this is the piece, it all seems pretty vanilla so far, I imagine. Then we go to the purely equitable by nature. What's by nature? Purely equitable by nature. The moment a man or a woman appears in judges' chambers, you just showed up by nature. The living, breathing, flesh, heart beating, oxygen processing, thinking man or a woman with private American national status, you are there by nature. Can a legal fiction appear by nature? They only appear legally by nature, on paper. A man or a woman appears in the flesh with love, joy, enjoyment, intent, and purpose. All of God's laws. That's equitable by nature. We also made a list of equitable. We'll add more stuff as we get to it. the moment your signature is on any piece of paper, you have equitable by nature right to that piece of paper. In equity. But at law, what do they make you feel like? Your signature. It doesn't belong to you. I pleaded this in open court, in federal court. I told them that I withdraw my signature from general deposit and redeposit the signature on special deposit, changing the nature and character of the rights between the parties. And that pleading stood there for like 45 days, and I was wondering what these guys are going to get back to this cert reply. I know they're going to have to. Can't leave that hanging out there. Sure enough, they did. And this esteemed Esquire guy, Mr. Attorney, said, and I'll just summarize, he said, I do not know that you can withdraw. No, I do not know that you can withdraw your signature. That's what he said. I do not know that you can withdraw your signature. No, at the time, I was thinking, see, what a bozo. Can't even respond, right? 3 years later, I meet Eric, and then I look back at that experience, and it just hit me. Why do you suppose he's saying he doesn't know I can withdraw my own signature? Do I own my signature? Do I own it in Roman equity?
No.
Do I own anything? Nothing. How can I withdraw something I don't own? I mean, even in the fine print on your mortgage, on that last sentence before you sign, it says, you've granted us permission to destroy the original and use copies as the new original. And everybody's trying to chase the original down. You already signed. You already signed, that is gone. That's also known as an equity clogging provision, but that's tomorrow. The point is, you don't even own your own signature. You're booty. You're conquered. Conquered booty. Under a Roman equity Caesar run out of one guy's office, serving the Pope. Now, here's the kicker. There's one piece here that bothered me for 2 years. And this is before I met Eric. We already know what equitable by characteristic is. And it's kind of cool that equity by characteristic, they can be seen in equity. A bank can be a beneficiary of a trust and go into equity. They just better bring their officers and directors with them. Real parties and interest. That can be done every day of the week. That's why people, when they walk out of this course, they'll say, well, I looked in Delaware, they have a court of chancery there, woohoo! Well, that's great and everything, but it's still martial. And if you look closely what they say they specialize in, because before 33 it was a real court of chancery. After 33 they specialize in corporate law. So it's kind of like they made an ambiguous sidestep of the martial change. They specialize in corporate law. That means that they're specializing in equitable characteristic. So they kind of took this, and that's what they're still doing. But still martial, make no mistake, guys. Don't be thinking you have to go to Mississippi and Delaware and these people that Tennessee that have these courts of equity still listed on their moniker or marquee. It's not changed for them. They're all martial. Okay, legal characteristic. 2 years into it, I just woke up one day and it hit me. I kept thinking, what is legal characteristic? What is legal characteristic? What is legal characteristic? Wait a minute. Legal characteristic in equity must mean the trustee who's holding legal title to a trust. He can go into equity as a trustee of legal title in that the legal characteristic that he's bound by is some kind of legal document that can't be seen in statutes and codes. What legal document could that be? What legal governing document could only be seen? I mean, check it out. There's no legal characteristic over here. It's only over here. So what legal characteristic document can only be seen outside the statutory realm? Trust indentures. A trust indenture. A trust indenture governs and is the law of the trust. A court of equity will see a trust indenture. It is the law of the trust.
It's the agreement.
It's the intent and purpose of the settler. That's the law of the trust. That's 5 Supreme Court cases right there. The intent and purpose of the settler is the law of the trust. The intent and purpose of the settler is the law of the trust. That's the law of the trust. So the trustee has to fulfill what? The intent and purpose of the settler. That's governing. It could be on a napkin. You could write it on a napkin. You could write your intent and purpose on a napkin. Actually, I went way too far on that one. You could do it with your mouth. God told you the power of the word, power of your mouth. He gave you all the power just with your mouth. I've got a book. It's got a whole chapter on forming trusts by parole, just with your mouth. Can you imagine just knowing how to sling trusts around? You know, I went to these early seminars, these gurus, these commerce gurus, and the Constitution protects your unlimited right to contract. And I said to one of them, nah, it's deeper than that. The Constitution protects your unlimited right to form trusts. And it's a whole lot more fun forming trusts because it's easier to prove and it's easier to enforce, because under trust law, the entire body of jurisprudence comes to your aid whether you invoke it or not. Can you imagine in contract how you have to list all the covenants and what are those, recitals in contract law? Recitals in the parties, whereas we both live in Belize, and whereas we both want to drill for oil, and whereas parties therefore agree, blah, blah, blah. That's contract law. Trust law, it's the intent and purpose of the settler that this, and this. Boom, done. No recitals. No mention of any maxims. No mention. It's automatic. The moment it's intent and purpose of settler's intent, it's automatic. And I was telling these people back then, I remember the day and the time. I took one of them out to eat ribs for dinner and paid for dinner, and after about 20 minutes he realized that he was studying the wrong law. He just was telling me, wow, I can't believe the power of trust law. I go, yeah, I've known you guys 60 days, and I'm sorry, I'm just not that into what you guys are doing. It's the wrong direction. You guys are going that way, and I'm going that way. These guys are going this way, and I'm going equitable by nature. Now wait till I teach you how powerful this is. Can't wait to get to that part. But I want you to know that this is where I had the epiphany, that it hit me that the Constitution for the United States of America cannot even be seen in a legal nature setting. So it's a legal by characteristic document. It is a trust indenture. It can't be both. When's the last time you ever heard a judge in court openly say that you're a party to the Constitution? I know Eric tried this. You got to test it. You got to test the waters. Go entertain yourself one day. Judge, before we get started here today, will you state for the record that you're seen as a party to the Constitution for the United States of America? Go ahead and say it, Judge. State for the record, you see me as party to the Constitution. Anytime now, Judge. And there's Eric. What do you say to you?
I will ask the questions.
I will ask the
You
questions.
will not ask me any questions.
Don't you think something simple like that in this country? Something simple like that in this country could be an easy answer. No, because you're sitting in what court? Legal nature martial court. Fake equity, all based on Roman equity, run by a Caesar. So, Constitution, trust indentures, banks being beneficiaries, totally legit. Purely equitable by nature. We're going to talk a lot about that one. This is where I spend all my time. You see, remember I told you we're threading the needle? The eye of the needle. That's how tiny a space I've been reading for 5 years. That tiny little space. It happens to be the single most powerful space in all of the history of law. And that's why God was telling you, have faith the size of a mustard seed. And you can move on. And you can say that if you just had faith about that big, it's impossible to have doubt at the same time. You can't have doubt and faith at the same time. Either you have faith or you have doubt. And if you have a tiny bit of faith, it's impossible to have doubt. So that's what he's telling you. Remove all doubt. It's easier to pass through the eye of a needle than a rich man get into heaven. We're going to pass through the eye of the needle. But our founding fathers intended us to be in this eye of the needle. They did the whole instrument like this. The unenumerated, protected, fundamental rights, substantive rights, all protected. All right, let's keep moving. We're going to get into equitable causes. Now, I listed a bunch here, but technically you only need one. You only need one equitable cause. An equitable cause is why are you in the court of equity? Why are you here? I added a new one this morning. The destruction of my rights. That's equitable. The destruction of my rights. See, equity is not about statutes and codes. We've clearly established that. But what is it really about? It's about rights. What rights to property. Rights to right title and interest to property. Gibson tells you that equity does not get itself involved with criminal unless it involves property. I think that's kind of cool the way he words that. He leaves the window open. You got a criminal matter, turn it into a property matter. I think he was talking in a day when there was concurrent. I wouldn't recommend. There's no connection between those realms now. And so you would never want to drag one into the other. But the point being, he tells you, equity doesn't get involved with criminal per se unless it involves property rights. So it's always about property rights. And it's about property rights governed under maxims that govern your right to property. Not statutes and codes. Maxims. 20 of them. 19. So let's look at the equitable causes. All suits resulting from accidents and mistakes. It's a beautiful thing. Everybody makes mistakes. We all do. In equity, you can go back and fix them. It's the prerogative power of a court of equity. They fix mistakes, accidents, as long as you're not negligent. You know it's a beautiful thing when you're a baby, equity comes to your aid as a baby automatically. Equity always comes to the defense of infants and children. They're always defenseless. Equity always comes to the aid of the defenseless. When your rights were sacrificed by your parents when you were born and they filled out that nasty registration statement at the hospital, and registered you and waived and didn't avail themselves of all of your private, natural, equitable rights under a private arrangement with the hospital. Your parents sacrificed your rights. It was not your fault. Quite frankly, I don't think it was your parents' fault. They did the best they knew how. But equity lets you fix that. See? Because now you're of the age of majority and you want to correct the past. It's a beautiful thing, equity. All suits resulting from trust. We're going to talk a lot about trust later today. All suits for an accounting. Next page. All suits for the marshaling of assets. Notice how he says the word assets, not securities. It's assets. And then he talks about, mortgages were always in equity. Check this out. In the year 1615, in our colonies was the first court case. And it was a mortgage case in equity. Okay? Mortgage in equity. Our founding fathers already brought equity to the colonies. Now, how many years until we get Declaration of Independence? 161 years? 161 years of equity running in the colonies. They didn't tell you that in school history, did they? So, why? Because it's what they loved about the English Jerusalem. They loved it. And it was right. It was a lofty Christian morality. Our entire law, judicial system, enforcement system, all based on a lofty Christian morality. That's equity. That's why they wanted it. Let's keep going. I noticed later it does say marshaling of securities, but I would never say the word security. I would say assets. Anyway, so you have in suits for injunction, remove clouds and quiet titles. But as you read this list, you'll start to see that the Marshall system copies equity. So all these things look familiar, because you can go get quiet title down at your courthouse right now. But is it equity, or is it fake look-alike equity? See? And I'll tell you what, when those bankers, Wall Street bankers, did the Emergency Bank Relief Act, they were having a party. It's right there in the record. They were having a party up in the balcony. Like they were being too loud. And they were warned multiple times, quiet down please, trying to, they knew what was going to happen. They were celebrating already. There was a landslide. They're going to make $1 trillion that afternoon. And they're going to get their World War II. Think that's a coincidence? World War II starts shortly thereafter. They needed their money. All those securities and assets that they swipe from us every day under the rules of Roman equity, because we own nothing. You must switch to American English jurisprudence to actually own those assets. They're not going to let you own them. I've got people standing in open court with a forensic in one hand that says that they made $24 million on the mortgage note, and they're being foreclosed on. And the judge says, there's nothing I can do to help you. And that's got to seem like real injustice. Totally legit, totally legal, no fraud. Stand in open court. Judge, they made $24 million with that mortgage. How are they taking my $200,000 house? I don't get that part. It's got to go into equity. That's where I'm at right now. Have you ever heard of a guy named Walter Burian? He's in a video. It's called The Greatest Game in Town. It's a most boring video you'll ever suffer. But you got to watch it. It's the rite of passage. He's a smart guy. Spent 12 years of his life, 14 years of his life studying. Have you guys ever heard of the CAFR accounting? Comprehensive Accounting Financial Reporting, CAFR accounts. Every county, every state has it. Go right on the comptroller's website of your state. He has your CAFR accounting right there. But here's what Walter figured out. Walter figured out, is that the postman? I'm waiting for the postman. My wife's sent me something overnight. It might help me get home. So, of course it would concern me if I didn't get it today too. So I'm not going to get it tomorrow. Burian decided to spend 12 years of his life collecting all these CAFR account reporting books and add them all up. And he determined in 1 year's time, and I'm going to say the year 2004, maybe it was 05 or 06, but in one of those years he said in 1 year, our comprehensive government, is what he called it, all the pension funds, the militaries, all of the CAFR accounting the government reports on themselves, totals in 1 year, 100 trillion. Meanwhile, what do they promote to us on television every day? We're broke. Not raise taxes. Economy's doing bad. Unemployment. The bubble. Stock market. Meanwhile, CAFR accounting, we made 150 trillion.
Would that all be held in trust for the...
Better be, because this is a temporary provisional government. It's temporary. That already implies it's all got to be there when they are no longer temporary. And who knows when that's going to be? Probably never. But the fact is, it's temporary provisional government, emergency war power government. And all of us are by default enemies. We're not allowed that accounting. That's why they call it the alien property custodian, because they take all of the enemy's assets and use it for commerce and war. And you and I are the enemy they're talking about. Just when you thought it was North Korea that they withheld assets on. No. It's your mom and dad sitting right in their backyard. It's an unbelievable moral sacrilege. It's just beyond my description. But there's good news. With the simple things that we can learn here, I'm going to show you how to create the new legal title. And I'm going to show you how the purely equitable title by nature. So I'm going to show you how your equitable title by nature extinguishes all of their titles combined. You can stack 40 attorneys and 40 banks in a court of equity. Not one of them can touch your equitable title by nature. Your one title by nature extinguishes them. Poof.
What was Walter's last name?
Walter Burien, B-U-R-I-E-N.
Thank you.
All right, let's turn to page 12. I don't think that post office guy's going to get here before noon. So, yeah, we'll just have to see.
Is it USPS?
Yeah,
Okay.
I have a tracking number.
Does it require a signature?
Yes, which is why I'm watching.
Were they going to deliver to the motel?
To this address right here.
Why would they go to the bank?
Well, I said conference room. Did I mess up?
No.
Not necessarily.
Okay. Well, if I have to chase down the mail guy at 4 o'clock in the afternoon in southern Wyoming, then I guess that's what I have to do, right? Let's talk about presumptions of law. This is section 445. There's 3 presumptions in equity. You know what presumptions mean? It means there's no way you can disprove them. It's just an automatic presumption. And one of them is that everybody knows the penal code. That's a presumption of law, even in equity. You're presumed to know all elements of the criminal law.
So you could almost call it a maxim then?
Yeah, presumptions of law, yeah. It's not a maxim. It's not. It's just a doctrine. That's what it is. It's doctrine. Now, mind you, this is a de jure government where they're talking about the penal code. So under this new government, is the penal code... I'm not going to go there. I was going to suggest this. Now the penal code is all commerce. The penal code used to be a de jure penal code for criminal. Now it's just pure commerce. Okay?
I think that was my question earlier.
But that would make me go down a different path. I don't want to mix in criminal with civil. I really don't do any criminal stuff, but if it were me, under the Roman equity system of criminal jurisprudence, I have some ideas. So, what's the next presumption? That everyone contemplates the outcome of his own acts. It's just a presumption. Certainly you knew by running that stop sign, you knew the outcome of your own acts. That's why everybody does their own acts. They knew the outcome. That's a presumption. But here's the third one. This is what kicked my butt when I saw this. Everyone has knowledge of a deed duly registered down at the county. Everyone has knowledge of a deed. That's a presumption. I mean, if you get a deed recorded down at the county, people say, well, how do you stop foreclosure? Why don't you go record a deed? Because if there's a deed, there's no innocent purchasers. If there's no innocent purchasers, then they can do whatever they want to do. Now you can give them notice that they did it subject to your rights and defenses as an equitable title holder, and now they're trustees automatically. That's equity jurisprudence 101. Why don't you practice due process and get your deeds recorded? I'll teach you how to do some deeds. All right. How we doing, Chief? I had a chief. He's already broke for lunch.
12:13, we do another 15 minutes.
Okay. Well, it's just based on he was recording. And you don't want a story and a chapter running over. I know that could be painful. All right. Where I actually use these things in my everyday paperwork. Every day. Some of this paperwork I'm sharing with you in the back of the book. We'll get that tomorrow. But this is priority. Okay, when I first met Eric and I got my driver's license needed to be renewed, and I wanted to get my status done so I could serve it on the Department of Motor Vehicles and see what they'd do. You know, I didn't know what they were going to do. So every time I fill out paperwork, this is what I do. Here's a piece of paper. I don't care what it is. Could be an application for a driver's license. Could be your SS5. Anything. I wouldn't necessarily be filling out SS5, but I'm telling you that everything that I do always has this on it. I write the word special, private, priority. What is included is not excluded. What is excluded is not included. If I say special, what have I excluded? If I say the word special, what is excluded automatically? You can't be a married bachelor. Public is excluded, so it's special. No. I'm sorry.
Private.
General. The opposite of special is general. Now, the opposite of the next one is public. Private. So when I say special and private, I'm excluding general and public. So I write special, private, and then I write priority. Why do I write priority? It's based on the maxim. Now we're getting into the maxims. Priority. It's the opposite of non-urgent. Enemies, belligerents, and rebels are non-urgent. I'm priority. It actually has force and effect in live court cases. In a few cases. One woman that I know personally, she had some hearing up in Washington State. She called me up, what should I do? I said, why don't you plead the conflict and variance? Just walk right up to the clerk and say, I have a conflict with your rules. So she got her courage up. She doesn't know a lot about this stuff. She got her courage up and went up to the clerk. I have a conflict with your rules. And the clerk said, hold on. Brought her in a back room. Shut the door and says, okay, how can I help you? What just happened?
Became private.
Private side of the court. Just for saying the conflict. She says it again, I have a conflict with your rules. They don't apply to me. Okay? The rules of equity apply to me. Immediately, the clerk tells the judge magistrate who's having an active session, they clear the courtroom for her. Clear it out. And they have her in there all by herself. To which the magistrate said, there's nothing I can do to help you. He's not lying. He can't. Because under the rules of equity, she's sitting in a legal nature court. At least he's being honest with her. We've had a case where the judge took his robe off, went down in the gallery, and sat with our hero under the rules of equity. Have another case where under the rules of equity, the judge put the words in our hero's mouth because under the rules of equity, the judge becomes your advocate. He helps you. Advocate is French. The word advocate is a French word, avocat, which means lawyer. So, I think of the stories, but when you invoke the rules of equity, they treat you special. I'll give you an example with private citizens. I had a private citizen call me one day, oh my gosh, I was just at the clerk's desk. I'm definitely an equity dude. I've never seen anything like it. She gave me her card and said, if there's anything I can do to help you, here's my direct line. Call me. If anyone has ever dealt with court before, is that normal? No, it's get the heck out of here, loser. Yeah, give me your money, get out of here. And this guy knew it. He was being treated differently. So it's pretty cool when you first feel this. It's like, wow, it really exists. There's really a man behind the curtain. And the second thing that happened to this lady is when she left the magistrate's courtroom, the clerk already had her transcript printed up in 25 minutes and then gave it to her for free. Here's your transcript. Special. It's when you get treated special, not general. So I always put special, private, priority. Okay? Now, we're going to talk about priority. Section 73, priority of right. This is a maxim. Where there are equal equity, the law must prevail. In a court of chancery in a conflict of equities, the party having the superior equity will prevail. Okay, let's read that last few words again. You got to hang on every word of this stuff, because they don't mince words. In a conflict of equities. You're in a foreclosure. Do you have a conflict of equities with the guy who's foreclosing on you? Is there a conflict?
Yeah.
Yeah, because the bank's pretending they have all the rights. The right to foreclose, the right to take, the right this, the right that. They're pretending like they have all the equitable rights by nature. Yeah, you have a conflict. You better put that on the record too. Objection. I object to their equitable by characteristic. You can say that on the open record. For the equitable by nature title is superior. Say that on the open record.
You say it one more time.
I object to their equitable by characteristic. Because the equitable by nature title is superior. Remember I taught you the difference between by nature and by characteristic? You're going to use this regular, everyday parlance in equity speak. Equitable by characteristic, equitable by... And you put this in your pleadings. Your Honor, we believe the bank is only holding equitable by characteristic. Which over the same subject matter, we're holding equitable by nature.
I object to their equitable characteristic.
I object to their equitable by characteristic title. Because the equitable by nature title is superior. Let's repeat what equitable by nature is. The moment a man or a woman, a private American national, signs anything, your signature makes you the superior equity by nature. Period. End of story. The moment somebody or yourself is the beneficiary of assets or any intent, purpose of trust property of any kind, you are the equitable by nature holder the moment you're the beneficial interest holder of any trust. The moment you're the beneficiary, you're automatically the equitable title holder by nature. Automatically. Okay? Let's read this one piece. In a conflict of equities, the party having superior equity will prevail. So, superior equity is equitable by nature. They always prevail. And if the equities are equal, and neither party has the legal title, then priority prevails. You guys remember the old Western movies when they had the old land rush? So all the wagon people would line up, they shoot a cannon, they just haul butt and go claim a stake in the ground. It was a race. Whoever got there first, it was theirs. Why? Because nobody's holding legal title, right? It's all brand new land. They just diced it up, put some stakes in the ground, they shot a cannon, and people went whizzing out there with their horses. First one to the stake gets priority. Priority prevails. That's why it was a race. No legal title holder. Okay? Under maxim. Let's continue. If no priority, then the defendant prevails. So if you have no priority, then whoever you're defending against wins. Then they win. If you have no priority. In which case would you never have priority? Now this is the beautiful thing about what we're teaching. Some people really, they'll put this together. You know, come back after a night's sleep and they'll go, hold on a second. What would stop me from having the superior equity if I'm the private American national, even if I've never signed anything? Aha. Because is the government holding legal title to anything? They're only holding naked title, which is custodial title. They don't hold legal title anywhere. The entire martial government's predicated on a statute. How much title are you holding under a statute? All right, so we're going to go to lunch on that note of priorities. You're going to speak fluent equitablese. Do you have priority, equal, or superior equity? Do you have prior? What's your equity in this matter? Is it prior, equal, or superior to mine? What's your equity, bank? What's your equity in this matter? Do you have a prior equity, a superior equity, or an equal equity? Can you show it to me? This is what goes in my letter that stops a foreclosure. Show cause.
That'd be like a prior trust. Do you have a prior trust?
Remember, I'm talking to a legal fiction, but I'm doing equity. We both know they don't have it, but I got to do equity. Dear bank, if you would like to show me you have superior equity, please do so. Show cause why the trust does not result over your failure to admit that you hold no equity in this matter, and that all the assets you're holding are my benefit, and that I'm holding the superior equity, and you're holding none. I don't put it in those words. Show cause why. I'll ask them, are you holding prior, equal, or superior equity? That's it. That's it. You can walk out of here and repeat those words as a private American national. Are you holding prior, equal, or superior equity? Which equity are you holding, bank? Taxman? Sheriff? Sounds to me like you guys are all governed by a statute. That's custodial title at best. Now I'm going to show you how to create the new legal title. And your legal title, by nature, extinguishes their custodial title. You're the only one that can issue the new legal title. Well, let's go to lunch.
Scary when you go to the
Oh, she got